Are we starting with the session?
Sir, I think it will start at 12:15.
Oh, 12:15.
We still have 5 minutes.
Oh.
Um,
I think we should start the session. Himani,
हाँ जी सर ओके सर
आप start करो session.
I am coming through my sister's laptop, so it talks as Lata Ramaseshan instead of Geeta. Okay.
ओके सर A very warm greeting and good afternoon to our esteemed panelists, faculty members, and participants who have joined us. Welcome to the first session of Third International Conference on Mediation, organized by Faculty of Law, University of Delhi, and Delhi School of Public Policy and Governance, Institute of Eminence, University of Delhi, in association with Mediation and Conciliation Project Committee, Supreme Court of India. It is so rightly said by Sir Joseph, an ounce of mediation is worth a pound of arbitration and a ton of litigation. The topic of first session is community mediation and mediation as indigenous form of dispute settlement in Indian perspective. To discuss various parameters of it, we have a stellar list of distinguished speakers, with each of them being an expert in their own domains. We humbly invite Honorable Justice Girish S. Kulkarni, Judge, Bombay High Court, our esteemed chair, Honorable Justice D. Bharatha Chakravarthy, Judge, Madras High Court, being respected the co-chair, and our admirable special guest, Ms. Geeta, Mediator, Ms. Giribala Singh, Secretary, ADR Committee, Main Mediation Monitoring Committee. We welcome you all. Without further ado, I would like to introduce our moderator for the session, Professor Dr. Rajni Abbi ma'am. Ma'am has a rich experience of almost 30 years. She is also a visiting professor at the Beijing Institute of Technology, Beijing, China, and visiting professor at Nanjing University of Aeronautics and Astronautics, Nanjing, China. She has also been the mayor of Delhi 2011 to 12. She is presently the proctor of the University of Delhi. I request you, ma'am, to formally welcome the panelists for this session.
Thank you so much, Himani, for welcoming all the guests. I welcome all of you. This is the third edition of the International Conference on Mediation, and this is the first session after the inaugural session. We have eminent panelists with us, Mr. Justice G.S. Kulkarni, Mr. Justice D. Bharatha Chakravarthy. I could also see earlier Mr. Justice S. Vaidyanathan had joined. We have Dr. Pramila Acharya also who had joined. As mediators, we have Ms. Geeta Ramaseshan and Ms. Giribala Singh, who are both experienced mediators and have an immense experience in this area. If we see the meaning of the word mediation, mediation is intervention in a dispute to resolve the dispute. I tried to find the meaning of mediation in the Cambridge Dictionary, and the dictionary defined mediation as the process of talking to two separate people or groups involved in a disagreement to try to help them to agree or find a solution to their problems. So apart from litigation, to which we are all used to, and apart from the adversarial system, mediation has evolved as a very important tool in the alternate dispute resolution. If we see the benefits of mediation, it is quick, the cost is low, it lessens the burden on the court, it can be flexible also, it is not rigid. Then in mediation, we can think of out-of-box solutions also. In the justice system, we are bound by the laws and the statutes and the notifications and the rules and regulations. But in this, we can find out-of-box solutions also. Then there is a personal touch also. The mediator has an empathy towards both the parties and can relate to both the parties. Since Vedic times, we have seen the examples of mediation have been before us. In the earlier session also, our esteemed Vice Chancellor also gave two examples. If you see Mahabharata, Lord Krishna had gone for mediation, and had that mediation been successful, the Mahabharata would not have happened. In Ramayana also we see Angad goes to Ravan's court for mediation and to resolve the dispute, but because that did not happen, the fierce battle happened. So we have two kinds of mediations. The court may refer the case for mediation, or we can have private mediation also. If we see our statutes in 1999, the CPC was amended, and Section 89 was added, whereby reference of cases which are pending in court can be sent for alternate dispute resolution, which includes mediation, although it became effective from 2002. We also have an example in the Consumer Protection Act, which has been amended, and the new act has come in 2019, where they've introduced the concept of mediation. All these efforts are immense and great efforts, so that there is less burden on the judicial system and the parties can be involved in mediation. I think an important area where mediation can definitely help is in marriage disputes. In marriage disputes, if the husband and wife are made to sit together and there is a competent mediator, I think many problems can be solved. So we start this session, and I invite, first of all, Miss Geeta. I think I hand over it to Himani. She will arrange in which order everybody is to speak. Thank you, Himani.
Okay, thank you so much, ma'am, for taking out time and joining us today. I would like to invite a special guest, Ms. Geeta, to kindly share her expertise with us. Ma'am has worked extensively with the legal aid system and has represented women living with HIV/AIDS, under trial prisoners, juvenile children, and minority groups that face discrimination. Ma'am has been a special public prosecutor for the CBI and has been invited by the National Judicial Academy, Bhopal, to deliver lectures. Over to you, ma'am.
Thank you, and thank you, Professor Rajni, for the introductory remarks. Honorable Chairman, respected judges, and distinguished members, I consider it my privilege to share with you a few of my thoughts on the concept of community mediation, leaving it to the other erudite speakers to address the various crucial issues. So I am starting it like an appetizer, with the main courses coming with all the other honorable judges and the rest of the speakers. Now, the civil rights movement in the USA started this process of community mediation, if we look at the a little bit of a global context, and it was then formulated into the Civil Rights Act. Primarily, it was a non-violent constructive model taking into account major concerns of the race of the 60s. It was hence initially prosecution sponsored, where community members would mediate minor criminal conflicts of neighboring disputes to reform the criminal justice system and reduce the community tensions. Now, the idea of community mediation in India, as in many other Asian, African, other countries, has always been prevalent in group cultures where group rights of the community are very important, sometimes more important than that of the individual rights. And this has not been referred to as community mediation in more ways than one. Therefore, local disputes, which we know by various other models, whatever we call them, whether it is panchayat, whether it is within two various other groups, etc., have always been addressing disputes of this kind. And actually, even litigants who come to the lawyer also go through most litigants, not all, also go through some kind of a settling their dispute within their community or through their families or through etc. Partially because nobody wants to come to the legal system. Now, this can be in a broad frame be understood as mediation, but what is community mediation in various contexts? I would just start with certain what I think are certain concepts so that it gets taken forward down. Now, if we take disputes at the very local level, I know Justice Call was not critical, but he said those are kind of, I mean, I also have problems with the way some kinds of disputes are addressed before a local body or a panchayat, etc. But one is that they act swiftly and more authoritatively. Now, whether the authority is biased or not would be a larger question. In a book Mediation Policy and Practice, which is co-edited by Justice Bharatha Chakravarthy, he refers to understanding community mediation as purposively mean any social group from neighborhood to organizations to nations which engage as a unit in responding to the conflict. Thus, almost all small disputes to major conflicts will be coming under this umbrella. And today we are seeking India's role to actually act as a mediator in the battle in Ukraine, between Ukraine and Russia, in more ways than one. Be that as it may, if I were to look at the positive aspects of community mediation, and I'll come later to some of the concerns, one is, of course, that it is constructive in the fact that the dispute is addressed at a very early stage, long before it escalates into various forms of tensions. It is, of course, speedy. It cuts across a huge amount of expense for parties, whether they go to the police or whether they go to a lawyer or whether they go to the court or whether they have to travel long distances to address and go to a formal legal process. It is very simple and direct in its access. Most importantly, it is concerned with the facts, or rather community mediation should be concerned with the facts and not on law. Therefore, if done well, it can have a very common sense approach to equity. There is again no strict adherence to evidence, of course, we know that. And there is a larger participation of the community. For example, in a dispute, you will have more people from the community coming in to discuss the issue. So say, for example, X brings a dispute against Y within the community. There will be some people who will come in support of X and some people who will come in support of Y. Now, this will not happen in a litigation, in a court of law, because no one will want to come in support of X and Y. They would be very lucky if they have someone coming in support of them, because no one wants to, as we say, take panga with the legal system. Now, how does this work in various ways? And I just wanted to share with you a very small example of, we had a very senior lawyer called Mr. Sampath, who completely believed in taking the legal aid to the people. I mean, at that time, it was not called as community mediation 20, 30 years ago. And he would always give us the example of, which Justice Kannan would also give us the example of a goat that was stolen by one man. And the owner of the goat had given a police complaint. Obviously, this man was then summoned to the station, etc. And that process went through. Now, when this legal aid went into and they had a process of going to the area where the dispute occurred rather than asking people to come. I mean, that was also happening, but this, when it went to the area where the dispute occurred, they thought of a very interesting strategy. You know, the district judge was the head of the legal aid, as it is with the Legal Services Authority. And they thought of a strategy where the district judge went to the house of the complainant. The moment he went to the house of the complainant was so flabbergasted, taken aback, and, felt a great pride that he said, a judge has come to my house. I am withdrawing all complaints against this person. So I was just sharing this with you to indicate, even from the formal legal system, if we were to use the Legal Services Authority in some ways, in an imaginative way, the way it can be used in 1,000 ways, of which, of course, subsequent speakers are going to speak on that, we can immediately address so many of these disputes, making parties, both parties in this case, feel very elated and happy that it had got resolved. Now, I address two issues. Now, in a mediation, and Ms. Giribala Singh is here, she will share the experience of Kerala and Madhya Pradesh, and which have taken on in a great way, and everybody is asking now that those models be replicated in other parts of India. And we know that community mediations refer every kind of a dispute, from a building dispute to between church members drawn everywhere, etc. in Kerala. I'm not going into that, but just to say that while members are drawn from the community, and we are constantly stressing on training. I mean, we are stressing for training, even for lawyers, that goes on. I would say that among other issues pertaining to the training, what is very important, and which is a constant process that we need to read and study, is that the training must address inequities and inequalities and understand discrimination. Because I would couple that with skills, where with our experience in family law, personally, with our experience in formal mediation of family law, personally, when it comes to family law, find that abroad the trainers are very specific. They say that you require a very different kind of a training in family law to address emotions, to address inequalities, as well as to address the issue of law. But if you ask any mediator here, we have had our experience where they would say, no, it's a company law case, we don't want to handle that, it's technical, etc. But when it comes to family law, every person would say that they are very competent, they can just take care of any dispute pertaining to family law. The reason being, yes, we do settle disputes, we do understand what a dispute in family law is, but the fact remains that sometimes we forget to address the inequities and difficulties that actually address within the area of family law. I add other issues with reference to understanding of family law, with reference to our understanding of how mediation actually works. But I also want to add certain aspects in this regard. One is that while it is very constructive, and I'm ending here with two examples, I just want to give you an example of a case in Tamil Nadu pertaining to, called S. Tamil Selvan versus State of Tamil Nadu, which came in 2016, pertaining to the author Perumal Murugan, and the judgment was given by His Lordship Justice Call. Now, in this case, the book was I'm not going into the facts except to say that a novel was written by Perumal Murugan. It was found to be very objectionable by different communities. There was a lot of protests, etc. And there was a potential law and order. The state felt that there was a law and order situation, and the district revenue officer called for peace talks. Now, in the framework of peace talks, the groups that protested about this book were in very large numbers, while the author had only his lawyer, and the DRO insisted that a written apology be given, and a written apology was given, where then he decided to withdraw and wrote a very wrote a very poignant Facebook post, said that the author is dead, etc. Be that as it may, when this was challenged in the court, the question of the issue of law and order, and I'm just quoting the judgment, state intervention in such matters are not simply matters of brokering peace. The role of the state is to ensure that the law and order situation does not go out of hand, that it is not achieved, but it is not to be achieved by placating anyone who seeks to take the law and order in their hands at the cost of the other and make it an unequal battle. Peace meeting itself is not faulty, but it ought not to have proceeded the way it did. This was the observations of the Honorable High Court, and I'm just ending it on one aspect, namely that if you see the bill under section 44 defines community mediation, the mediation bill defines community mediation as any dispute likely to affect peace, harmony, and tranquility amongst the residents or families of any area or locality, and may be settled through community mediation with prior mutual consent of the parties to the dispute. And hence, disputes of this kind, if it is to be settled within community mediation, need a very, very different kind of an approach. And with these words, I thank you all for giving me an opportunity to share my thoughts on this issue.
Thank you so much, ma'am, for educating us about the subject and sharing with us such valuable points. I would like to invite a special guest, Ms. Giribala Singh, to share her rich experience in the field. She is a judicial officer of batch 1990. Apart from presiding over courts, she has been dealing with cases under Prevention of Corruption Act, POSCO, dacoity. She has also served as Registrar, High Court of Madhya Pradesh, and Member Secretary of Madhya Pradesh State Legal Service Authority. She is a trained mediator and trainer from MCPC. She is presently the Principal District Judge in Bhopal. Ma'am, please. Over to you, ma'am.
Yeah, good afternoon. I hope I'm audible.
Yes, ma'am.
Honorable our chairman of this panel, co-panelists, and learned participants. I extend the gratitude to the organizers for this very relevant conversation, especially not only focused on docket explosion in the courts, but docket exclusion, particularly when it affects the marginalized sections. So my experience in Madhya Pradesh has been picking up from where Madam just left. It has the accessibility to justice that has been the major challenge. And for this, let us consider in Madhya Pradesh, we call it the geographical heart of India. It is home to 21 tribal communities. 3 of these communities are particularly vulnerable tribal groups. And we rank a bit low on the Human Development Index. Sometimes modes of communication, transport are very rare. And for the common man, food is God, rather than flocking to the court in an alien atmosphere, unable to understand the language, daunted by the black robes. So it is this aspect which we took forward as a community mediation program. Largely, it is based on the Kerala model. And for this end, the Mediation Monitoring Committee of the High Court of Madhya Pradesh, after we took formal consent, we started identification of the persons whom we could take on as the mediators. Let me also share with you that it's not that before the courts existed in the present form, there was no method of resolution of dispute. Yes, we had the tarbis, we had the village panchayats, but every panchayat had its own flaws and fallacies. The resolution of disputes was largely steeped in religious blend, deep undercurrent of political power imbalances. And the purpose why we took forward this step was to also understand where is it that the community sometimes their own tribal customs are in contradiction to the law. So we also needed to spread the word regarding existing statutes. For example, if you observe in the, there is this Bhagoria tribal dance. It happens among Bhil, Bilala communities, largely in Jhabua and Ali Rajpur areas. So there is this customary dance around Holi, where pubescent children are allowed to run away together. If they are happy, they may start a marital life. But what happens is the end result of it is often that these are the people found violative of the POCSO Act. Then we have the particularly vulnerable group, Seheria community. They earn a livelihood out of skinning animals, but they are often in contravention of the Wildlife Protection Act. So all this exercise meant also to help people to transform their thinking. Like with the Saharias, we had to interact with them differently. Every community, a community or a culture is not created in the halls of parliament. It was always there and it will continue to exist. So we had to tell them that the body of the animal is the house of God. So they were able to understand, but we also at the same time, we had to also cultivate and to analyze new ways of living, because that was the only traditional art that they knew till now. If you would permit, I'll just share a slide on the basic, the various modalities that we went about for this. Please put on the screen. So a community mediation program, we invited people from different communities, and as of now, we have more than 21 communities who are sharing. Who are part of this entire program. And is it visible? I hope the slide is visible.
Yes, ma'am, it's visible.
Okay. Now, training these people from the community was another challenge, because in some instances we needed interlocutors also. And apart from that, you know, in Madhya Pradesh, every 20-30 kilometers, the language, the dialect, the food habits, everything changes. But with change, there is this basic emotional content, and communities are very strongly enmeshed with this emotional content. Next, wala karo. So we inculcated within our 20 hours training program, we involved teachers from psychology and also from sociology. We took the services of the teachers from the university. And at the time when especially we took the advantage of the Corona situation for calling these teachers, because the teachers helped us through the online modes. Then we did mock exercises. Now the difficulty was that people who were selected were not already understanding the intricacies of a mediation. And our purpose also was not to replace or to supplant the existing modes of settlement. Rather, it was to facilitate settlement of conflicts with marrying the concepts of mediation into the whole mold. Next. So we had nominations from various communities. Next. And the community mediation volunteers, next please. They are above the age of 25 years, good reputation, nominated by the social service organization, no criminal background. They had to have a zeal for social services, preferably graduates. There was a screening process for all of them. Next. And subsequent to that, you know, when we did the role plays, we observed that because they had their own respectable presence, they had good language skills, but they had this dictatorial method. So with this dictatorial method, we had to bring in the good concepts of mediation, of telling them how it can be the people's process, how it should be voluntary, how they have to rise above their own prejudices and biases by first recognizing what is their bias. So these were the major challenges at the time of the training. But once they were trained, we could not leave them just on the field like that. So we had observers. We have this whole program is modulated through the District Legal Services Authority. The community mediation volunteer, he goes through the phases of a trained mediator. But the monitoring by the District Legal Service Authority is largely to see that the agreements are in conformity with the law. We don't want to have another system which has the air of authenticity and still doesn't adopt the legal framework. So the continuous observation was one important hallmark of this. Next. And as of now, we have more than 21 communities, as you can see. Next. So these were the basic steps which we took. And let me tell you the figures as of from February 2022. I just gathered those figures. So we have out of 168 matters which were referred to the these centers, 67 were resolved, which is about 39 point something %, which is higher than our court-referred litigation settlement matters. So apart from this one good initiative, we also try to bring it within the umbrella of our Gram Nyaya Act. See, the Gram Nyaya Act 2008, it has been adopted by Madhya Pradesh, and as of now, we have 89 Gram Nyayadhikaris and Gram Nyayalas are across the state. Over a passage of time, these Gram Nyayalas had become confined to the court rooms themselves. It was comfortable for the advocates. The matters of the filing was going on there. The judge didn't have to travel. But once we trained these volunteers, we encouraged our judges to go forward to that village which is identified as the Gram Nyaya for a bunch of villages around the Gram Nyaya. And these volunteers, I foresee that they can give a lot of assistance to this scheme. The rules have been put in place, but as of now, the state government is still doing some homework on the kind of honorarium that would be payable to these people. And apart from this, we also work towards the litigation-free village scheme. It's a scheme of Madhya Pradesh. 2002, it had started. Then there was a lull period. Then once we had trained these people, they voluntarily went forward. And as of now, we have 181 litigation-free villages. It works in coordination with the village litigation clinic. And every such unit comprises of the sarpanch, the patwari, the teacher, the headmaster there, the village the forest guard, and of course our legal services authority, to help them to come out of the confines of any kind of litigation and to have to run to the court, because going to the court means one day's bread and butter is written off. So in the ultimate analysis, as I see it, the idea of Swaraj, I think, which Gandhiji conceptualized, is not the acquisition of authority. It's the acquisition of the capacity to deal with conflicts at the local level. And as I said, culture is not created in the halls of parliament. Therefore, the culture of resolution of dispute must begin locally. So with these words, I can hand it over to the next speaker. Thank you so much.
Thank you so much, ma'am, for telling us so comprehensively about the entire process of mediation. I would like to invite the co-chair for our session, Honorable Justice D. Bharatha Chakravarthy, Judge, Madras High Court, to share his extensive knowledge and enrich our discussion on this topic. Your Lordship is an accredited mediator from 2005 with the Tamil Nadu Mediation and Conciliation Center, having mediated around 400 referrals. Your Lordship has been the Joint Secretary and Coordinator of the Madras High Court Mediation Center. Your Lordship has authored Seek Mediation and Awareness Booklet for the Tamil Nadu Mediation Center, co-authored the chapter Mediation and the Madras High Court, translated the Mediation Manual of India in Tamil for the Tamil Nadu Mediation Center, and ran an mobile app, Lift Law in Fingertips. The virtual floor is yours, Your Lordship.
Thank you, Himani. Honorable Chair, my fellow speakers, and the honorable judges and mediators across India who are present. As a matter of fact, on 9/4/2005 is the day in which the first Court Annex Mediation Center was started at the Madras High Court. We celebrate this day as Mediation Day, so happy Mediation Day to everyone. Coming straight to the topic, my interest about community mediation started thus. Like in 2005, when we were trained on the mediation, trainers were mostly from abroad. Now, in every session, we used to talk that mediation is not new to us and the panchayat system is already there. Therefore, one of our trainers asked me, do you really think that the panchayat system you all speaking about is mediation? So this is how my observation started. And I had to present a paper on the Asia Pacific conference conducted by Samadhan in Delhi. And for that purpose, we took a survey of about 15 villages and presented our results. And the survey gave us two results. We had the first answer from Justice Kaul, like whether these panchayat, which is in the present form, can be considered as mediation at all. No, most of these panchayats, which are now on the caste lines like Cup panchayats or in the fisherman villages, you know, they dole out verdicts. You cannot call them as mediations. Therefore, we found the answer that most of the panchayat system, which is prevalent in the present day, cannot be termed as mediation at all. But the revelations were that more than 80% of the families we interviewed had conflicts resolved through community mediations, namely the elder mediators, the faith mediators, and so many other persons. That was the revelations from which we took these studies. For example, like the elder mediators, namely the uncle or the elderly person from the neighborhood or a retired school teacher, have been resolving so many disputes, partitioning, you know, one person gets the cylinder, the other person gets the gas stove. The one person get the bullocks, the other person get the cows. The small hut, no, they divided into two. They opened another entrance. And these grassroots level disputes, which cannot even reach the doorsteps of any court or even for a police station, or for a majority part, were resolved by these grassroots mediators. And our further revelations were these persons like barbers, the traditional village barber, perhaps because of the fact that he is able to, you know, have his head on the hand on the head. Like people used to share so many personal things with him. A father and son who is not in speaking terms, only this person carried the proposal back and forth to sell a family property or to acquire a piece of land. The postmans who are delivering the old age pensions were mediating the dispute in those families. How this old lady, how much of money she kept for herself, how much money she gave it to her son or a grandson. So like these persons who involved in the community labor and service, they were doing so many mediations which we are not even recognizing. Then comes the faith mediations. You know, faith mediations now, because the most of the conflicts, you know, neighborhood conflicts arising out of behavioral problems like idling, the son who doesn't go for any work at all, just hanging out with his friends in the tea shops, and psychological, the alcoholism problems, the husband or a family member being, we all know, we are all very familiar with the problems about alcoholism, psychological disorders like depression, etc. They go to the temples. You can most often see these persons, you know, they waiting in the temple itself after everyone having gone, having a word with the Pandit. No, apart from performing the rituals, these Gurukals are the Pandits in these small temples. They have a word, they speak to them 5 minutes and they carry the proposal back and forth with the family members, and they were able to resolve so many disputes in the neighborhood. And we know that the pastoral mediation, especially in hilly areas, remote areas, among the fishermen communities, the number of pastoral mediations is very high. And we know from among the Muslim communities, the role performed by these Jamaats. No, I'm excluding all these forceful mediations and the other unethical kangaroo courts. I'm only talking about the mediations in the real sense, where people are heard, proposals are carried back and forth, and things are resolved. So a huge number of disputes even now is resolved by these faith mediations. Then there are these organized organizations such as societies, self-help groups, the sector organizations, especially in these urban habitats where the low income groups are involved, where these community leaders and the office bearers of the societies are involved in this resolving a large number of these disputes, which we call it as the kitchen garden disputes, like nuisances about solid waste management, letting out your sewerage line, the boundary line disputes, the disputes such as noises and the other things which are being in a large manner held. Next comes the involvement of the government and the governmental agencies. I divide this into two. First, the law enforcement agencies, such as the police officers. Many of these dispute about the drunken brawls, fit of anger, hurts, even the policemen involve these community leaders and volunteers to broker peace from them. Like Geeta was giving the example of how bad it was done in one case. I am also sounding about in many cases, it is done in a proper manner, which will come within the four corners of mediation, where there is self-determination, where the parties are heard, proposals are carried back and forth, and the matters are resolved. And secondly, the most important thing is the benefits from various government schemes gives rise to a large number of disputes, which can be resolved only through community mediation. The first and foremost, I want to flag this organization now under the Pradhan Mantri's Yojana, water facility is being extended even to the remotest of the villages. But every day, lakhs and lakhs of these disputes arising between neighbors, drawal of waters from hand pumps, from these pipelines, from the tankers, because the resources is limited. Time of the people is limited, gives rise to a large number of dispute among the common folk, common women folk, which has to be addressed only by way of community resolution. The location of the government facilities such as bus stops, burial grounds, ration shops, health centers, panchayat offices gives rise to a large number of conflicts every day throughout our country, which had to be, community mediation is the best solution. In fact, these disputes, if left unattended at the early stages, manifest into communal hatred and crimes. And it also travel up to the Supreme Court as PILs in many cases. Therefore, community mediation is the key to resolve all these disputes. Especially this 145 proceedings within the realm of criminal law, the peace committee meetings run by these revenue divisional officers and the other officers of the government is a candidate for community mediation, where if trained volunteers in a proper form are involved, and if the mediation, is conducted in the process, it can go a long way. See, that is what all that is required is not the mindset of what we as the court annex mediation mediators, the court annex mediators or the lawyers alone do is the mediation. But what Gandhiji said is Sat, that is finding of the infinite truth by understanding only the perspective of the parties, resolving the dispute by infinite love, where both the means and the end both are non-violent, leading to the amicable resolution of the dispute, so that the immediate communities take charge of the conflicts arising in their immediate communities themselves is the key. Because in a large country like India, we are only dealing with a very, very minor fraction of the conflicts which arise every day in the court and the court system. And it is these community people and community mediations who still deal with the major part of the thing. This is what is called as the peace virus theory, that non-violent behavior arising out of this resolution of the dispute in an amicable way has the mirroring and cascading effect on the rest of the society, which travels up to the height of the pyramid, having a very important effect on the society. And that is what I intend to appeal to this audience. And thank you very much for the opportunity. And I remain with this. Thank you.
Thank you so much, Your Lordship, for taking us through the very intricate details on mediation and beautifully capturing the entire essence of the discussion. I would like to humbly invite the chair for today's session, Honorable Justice Girish S. Kulkarni, Judge, Bombay High Court, to share his extensive knowledge and enrich a discussion on this topic. Your Lordship has represented various public sector undertakings like Airport Authority of India, Air India, Reserve Bank of India, etc. In April 2009, Your Lordship was appointed as a panel counsel by the Honorable Bombay High Court to represent in the cases against the High Court. The virtual floor is yours, Your Lordship, please.
Thank you so much, Imani. My esteemed brother, Justice Bharatha Chakravarthy, distinguished panelist, I think we have selected a very important and significant topic for today's discussion. With the erudite address of Justice Chakravarthy and his experience in mediation, I think I am no match. But I would speak something, whatever I have gathered in the course of my judicial journey of about 8.5 years. And also some experience which I have gathered at the bar, having practiced for about 21 years. Now, when we talk of mediation, the idea comes to our mind that, yes, why we are talking about mediation is that we are overburdened. The dockets of the courts are swollen. These kind of disputes coming to the court can certainly be taken care of at a different level. Why they come to the court? Why not different means and methods can be found out? And ultimately, to which now, as pointed out by Ms. Giribala Singh, that it may not be certain times a very effective resolution before some forums, even if it is taken into mediation. Human thinking is complex. These complexities of human behavior are certainly creating conflicts. Now, yesterday I was discussing something with my colleagues, and I must share this with you. The question came that if there are two cakes and there is a group of persons, the first cake being a cake of conflict, and the second cake being a cake of peace, which cake we as human beings would like to have? And a very interesting answer came forth from somebody. So it is better to have both the cakes. It was a very interesting answer. Why both the cakes? As I said, we are cursed with this tendency of having everything. So we eat both the cakes. And I think it is very important to have both the cakes. Why? Because unless we eat the cake of conflict, we don't know how good is the cake of peace. And this is what human tendency is. It has been there since ancient times, as appropriately said by all the panelists and also in the inaugural session by Justice Kaul. Now, when we talk of mediation, we look at a third party who is an independent person who is going to look into the problems of two parties who are at loggerheads. He would sit down and try to conduct a kind of negotiation, see what is in the interest of both the parties, and ultimately advise them that please resolve the issue in a particular manner. They are definitely peacemakers. Mediators, I would say, are peacemakers. In a very recent function which I had the privilege to attend, where Honorable Justice Hima Kohli was presiding over the function, and which was also associated with mediation, and it was a function of release of a book recently. Her ladyship quoted Dalai Lama, and who has very eloquently said these few lines. I'll just read out. Dalai Lama says that the planet does not need more successful people. The planet desperately needs peacemakers, healers, restorers, storytellers, and lovers of all kinds. And to my mind, mediators eminently qualify as peacemakers. So all my congratulations to Justice Bharatha Chakravarthy for having achieved 400 mediations successfully. Now, talking about the indigenous form as it has stood in the history. Now, history of human progress and civilization itself is on conflicting human opinions in different spheres of our human activity. So hence, the need becomes of a pattern of collaborative and amicable resolution of disputes, which has always been the need of the time. Talking about history, now scholars have traced the history of mediation about 3,000 years before Christ in Egypt. Then we have also seen and heard that King Solomon, that is 1990 BC, was a renowned mediator. Prophet Muhammad resolved disputes between two warring groups. Confucius, a Chinese philosopher, had a major influence in Southeast Asia, in Japan, in China, in Korea, in Vietnam, and Thailand. His philosophy promoted harmony and deprecated aggression. Also, as pointed out by the panelists, in our own system, first was the Vedic system in which principles of wisdom, reason, and prudence was the unwritten law. And that was the originating philosophy, I would say, of mediation. Towards the end of the Vedic era, also we have read that there were epochs of debates which were conducted in the open to elicit ultimately what is the truth in an open system. Then we have the Dharma Shastra. During the development of basic laws, resolution of disputes by non-adversarial methods were adopted. And there were tribunals, in fact, like the Kula tribunal set up by Yagnavalkya, dealing with disputes between members of family, tribes, community, caste, etc. Then we had the Shreni tribunal, where artisans came together and resolved their disputes. Similarly, we had the Puga Association of Traders. We had parishads, where learned members from the society could settle disputes. Ultimately, these were all based on the principles of equity, good conscience, and justice. Then again, we go to the Arthashastra of Kautilya, which is the economics, where the customary usages and practices to settle boundary and trade disputes were followed. Then came the village and community mediation. In a village panchayat, 5 elders were to act as conciliators. However, as pointed out by Ms. Giribala Singh, that there were certain flaws and fallacies. It depended on who is the person before this panchayat. What is his status? Is she a lady who is actually crying for her rights to be restored? Or is it some poor family in a village? Who are these panchas? What is their mindset? They are influenced by what considerations? All these were all big question marks. And therefore, whether at all it was an acceptable mediation and a decision being taken by the panchayat was always a kind of some debate. Because it ought not to be that somebody is foisted with a decision, and that too in the form which the panchayat would take. Then we see religions also recognized, like imams used to settle disputes within the mosque. We had the Buddhist principles which encouraged a path to achieve calm, insight, vision and enlightenment, with a message that let's go of the past and enter the future. Temples were also centers for social services and charitable organizations. In the pre-British era, Mahajans, businessmen who would resolve disputes between merchants through mediation. Then in the British era, the Britishers were not too happy with the indigenous mediation practices which were followed in our society. They felt that these practices were discriminatory, as we discussed about the panchayat practices. Then came the most important phase in the mediation, and that was during the British era. We saw the Gandhian theory of conflict resolution, which was recognized. The biggest settlement and negotiation, a negotiation which is now remembered by the entire world, through continuous negotiations and mediations, was the settlement arrived with the British regime to achieve Indian independence from the British rule. I don't think that in the 20th century there can be a better settlement than what we have achieved by the principles of ahimsa and satyagraha, which is the non-coercive and non-violent resettlement and truth and justice. So the message of such kind of settlements and negotiation was also taken from where it came, because the principles and ideology of ahimsa and satyagraha was inculcated and first practiced by Mahatma Gandhi, father of our nation, in South Africa, when he was himself discriminated when he was walking on a footpath and he was asked to go away. And then the idea came to his mind that what is all this practice? He said, I will not resent. I would not file a complaint of any racial discrimination against the police person, but I would raise a movement against this. And this was the ahimsa and the satyagraha which he brought to our country. So it went back to South Africa from India. That is Nelson Mandela, who was inspired by the Gandhian principles. He started this movement, and his mediation and negotiation led South Africa to a transition from apartheid to multiracial democracy. So this has been the success route of mediation. Now in the present day, indigenous conflict resolution bodies can be found in different states and which are in different forms. We have the village councils and courts, gram kacheris, nyay panchayats, khap panchayats, as brother has pointed out, and we have the katta panchayats also. Now, as Justice Chakravarthy pointed out, that large number of disputes we don't even know, they get settled at these levels. But nonetheless, then why our courts are flooded with all kinds of cases? You see the civil courts, you see the high courts, and also you see the Supreme Court. The dockets have exploded to such an extent that it has become totally unmanageable. So what should be the way ahead? Now, time and again, as we have seen from the amendment to Section 89 of the Code of Civil Procedure, when it has been recognized that the court would advise parties in a given case that why don't you go for alternate dispute resolution. Now that was in 2002, that is the 1999 Amendment Act. Took 3 years to be brought into force, but thereafter the journey has been quite good. But the Supreme Court, also being conscious of these requirements of the contemporary times, I would just list out in 2008 in AFCONS, has dealt in detail about which kind of disputes can be taken to mediation. Again in 2013, in K. Srinivas Rao's case, the importance of mediation in matrimonial cases was highlighted, as also Professor Rajni, Abbi had pointed out. In 2014, in Vikram Bakshi's case, in commercial cases, the Supreme Court again commented that how important mediation would be. Then in 2018, in Bijoy Sinha Roy's case, Section 89 was sought to be impressed upon the consumer forums. And lastly, in 2019, in Krishnamurthy versus New India Assurance Company, the court felt that why can't there be a feasibility of enacting a Mediation Act? And that is how we have the Mediation Bill of 2021. So this is the history what we see of the mediation movement in our country. Now, we have already seen that at least in as far as the state of Maharashtra is concerned, we have the mediation centers attached to every district court. So I was wondering that ultimately, with all this enunciation of law by the Supreme Court, now we have having this conciliation centers in the district court itself. What a wonderful signal it is to all the stakeholders that you have the court and you have where you, if you go to the court, you have the regular adjudication of disputes in a manner which is in the law books, and you have a mediation center where all this, the arbitration can take place, or a conciliation can take place, mediation can take place. So I was reminded of what something happened in the United States, which was in the year 1976. There was a conference of lawyers, of judges, and educationists, where they came together to discuss about the explosion of dockets and the variety of cases which are possibly unwarrantedly coming to the court. And what was propounded, the conference is known as the Pound Conference of 1976. And what was propounded was that let us have a system of multi-door courthouse. So you have different doors in the courthouse. Now, which is the one you want to select? You want to go for litigation? The door is here. You want to go for mediation? Another door is open for us, for you. There is another door for arbitration. So, a multi-door court. Also a system, as Brother Chakravarthy said, of neighborhood justice centers was discussed. Now, I think it is high time for us also to have the neighborhood justice centers, where before going to the court of law, the concerned persons can knock the doors of the neighborhood justice centers, and which should be an initiative taken by the government, that yes, please come to us, as in case of panchayats and other indigenous methods which we are following. Also, for the urban centers, for all the other district places, district centers, and which I think would definitely be expedient. It would be in the interest of the citizens that they are not required to unnecessarily, fall to all these the litigation and the court cases. Now, what should be the way forward? The way forward, in my opinion, should be to take mediation to still higher levels. The mindset plays a very important role. Now we have a conflict. We have a difference of opinion with somebody. Ultimately, it's so difficult for the parties. If you step into the shoes of the parties, they feel helpless. What do I do? They are disturbed. They have no peace of mind on these disputes which are bothering them. It may be any kind of dispute. It may be a personal fight. It may be a issue on land. It may be a issue on some other, money, or maybe anything. The mindset of the people traditionally is that yes, we have the courts. We may have to go to the court, and which is not a very pleasant thing for them. So the mindset of the stakeholders, that is the litigants, the lawyers who are working on at the grassroots levels, and also we as judges, as trial court judges, need to inculcate this. That how best we can come forward and prevent a particular dispute being going to the court. The lawyers, I feel, play a very important role, and that was highlighted recently by the Honorable Chief Justice of India in his speech on mediation. That they are the ones who would be advising that no, this is a case where you can sit down across the table in a mediation and resolve it. There is no point in going to the court. So, what has been now conceived by the Mediation Bill of 2021 to have pre-litigation mediation in some form ought to be made mandatory. I completely agree about the flaws as the Honorable Chief Justice Malimat has pointed out in the bill. But ultimately, all these are matters which are still to be debated at the floor of the Parliament. And certainly there would be a appropriate discussion on all these issues, that how we look at this particular approach and the needs of the litigants and the community. Now, a very important facet was touched by Justice Kaul in his address, where he mentioned that the government is the biggest litigant, and so many cases come to the High Court and the Supreme Court, as also they are filed before the other courts. Why can't there be a machinery at the level of the government? Now, take for example, And this is very interesting, that a writ petition under Article 226 is filed. A writ petition under Article 32 is filed before the Supreme Court, which is itself a fundamental right. Now, you can't prevent a citizen from approaching the court under Article and invoking Article 226. But in hundreds and thousands and lakhs of cases, there is a demand for issuance of a writ of mandamus. That please direct a particular public authority or a state or the government to do a particular thing. Here is what is the injustice to us. But the precondition always has been said that there has to be a demand for justice. So, before you knock the doors of the court under Article 226, you have to write a representation to the concerned public body that this is my grievance. Please take care of my grievance. Never it is attended. And ultimately, there is no remedy for you but to go to the High Court, invoke 226, invoke Article 32 in the given case. So the point which I want to make here is that the government and public bodies need to scan, scrutinize, and decide these representations, and for which they need to have a robust mechanism, a body of competent officers who, if they just spend some time and apply their mind, I think 90% of the litigation against the government would be put to an end. And this would be another form of dispute resolution. The dispute would be resolved there and then after looking at the representation. These are all very small representations. I'll give you an example. I hope I'm not exceeding my time. I'll just give you a small example. A pensioner, a person who has retired as a teacher, is not paid pension. He makes a representation, it is not answered. Ultimately, poor fellow, livelihood, he has to come to the High Court and file a petition. Please direct them to decide my representation, pay me pension. Now, is it worth a case coming to the High Court? Why can't the state government or any other public authority decide? But no, we will not decide it. So this ought not to be the approach. And therefore, a robust panel, a body at every place like district level, the state level, and particularly for the different category of cases should be formed by the government so that the litigation against the government is reduced. And also, for making the mediation movement successful, at the trial court, we as judges need to really take special efforts to see that which case can go for mediation. That we have that knack as judges, that this is a case which ought not to be actually taken for adjudication at all, and it should be sorted out there and then. So thank you so much. And I think that this discussion will definitely take us forward on this movement. I thank the organizers and all the panelists for sharing their thoughts. Thank you so much. Namaskar.
Thank you so much, Your Lordship. It was an honor to have you today with us. It was a very comprehensive and solution-driven session. Now, I would like to request Professor Dr. Rajni Abbi ma'am to share concluding remarks and propose the vote of thanks.
Thank you, Himani. In fact, this session was so educating that probably we as teachers also learned so much. I am not much into mediation, but today I saw such aspects of mediation come forward that I'm now so interested in mediation, and I promise that I'm going to study it a lot now. It is, in fact, my proud privilege to thank all the panelists to give such valuable their contributions and suggestions in this conference. It is with great gratitude I thank all of you for sparing your valuable time. If I sum up very briefly, the first panelist, that is Geeta Ramaseshan ji, she talked about community mediation started from the Civil Rights Act of the US and shared her experiences. She even hinted at the role of India between the war which is nowadays going on. Now, the best part of her whole endeavor was that when she gave an example where the judge went to the complainant's house and the complainant was surprised to see the judge. Training regarding the mediators must be addressed to, and they must understand the iniquities and the inequalities. And this should be coupled with their skills and experience. Thank you, ma'am, for sharing your experience, Geeta ji. The next speaker, Ms. Giribala Singh, who has vast experience in working in Madhya Pradesh. She said that in tribal communities, accessibility to justice is still a challenge, and resolution of disputes, they are done by religion also, by politics also. And her best statement was that culture is not created in parliament. There are around 21 communities in Madhya Pradesh where mediation is still working. And the fact that 39% matters have been settled, I think, ma'am, this is really a remarkable feature, because if you consider these 39% cases are less gone to the courts now. So even if it is 39% resolution, I think it is really very good. She also talked about Gram Nyayalayas and village litigation clinics and Swaraj, that the capacity to deal with problems locally. This is very important in mediation. Then we come to Honorable Mr. Justice D. Bharatha Chakravarthy, who is the co-chairperson for this session. He talks about the grassroots disputes being resolved, where even a barber, a postman can mediate. And he also talked about faith mediation, where pundits, pastors, and Jamaat and the Maulvis, they also resolve a lot of disputes. He also talked about the kitchen garden disputes. Government and government agencies, they also help in mediation, where a police officer can also resolve the dispute at a local level. The benefits of government schemes, according to him, they also create a lot of problems and disputes which have to be resolved, because according to him, and even I feel, that they can definitely raise a feeling of communal kind of feeling, and this can increase. His formula of Gandhiji, that any dispute can be resolved by satya, love, and amicable resolution, that is the peace virus theory. That was really great. Thank you, sir, for your erudite explanation. Honorable Mr. Justice G.S. Kulkarni from Bombay High Court, who's the chairperson for the session. Thank you, sir. You took us from the right history of mediation till today's journey. And you're absolutely right that the dockets of the court are overswollen and burdened. You gave the illustration of two cakes of conflicts and peace. They cannot be alive without both of them. Mediators are definitely peacemakers, and not only peacemakers, if I'm allowed to add there, they can act as pacemakers also for the body of the society. And Dalai Lama's quote also was very well taken, that planet does not need more successful people. It really needs more of healers, of lovers, and peace-loving people. The history of mediation, you took us back to 3,000 years before Christ, and King Solomon, Muhammad Prophet, Confucius. In India also, we've had a great history of mediation, right from Yajnavalkya to Kautilya to the village conciliation system, the panchayats. There are flaws in the panchayat system also, but what we need to do is not to scrap the system, but to correct the system. That is what I personally feel. The Britishers were not happy with the indigenous system because they could not impose their own laws in the indigenous system. So they wanted their own system to be evolved. Now, in current cases, the mediation is going on in marriage cases and commercial cases and consumer cases. And therefore, I think the mediation bill should be immediately passed, and the neighborhood justice center, whereby before going to the court of law, this center works and helps everyone. I think your idea of taking mediation to a higher level, where the mindset of people changes. And of course, I believe that because government is the largest person which is there in court. I think that if government resolutions are solved, then half of the problem is solved. All the panelists contributed so much. I've learned myself so much today. Thank you, all of you. Over to you, Himani.
The insight shared by the panelists have truly been thought-provoking and informative. I thank all of you again for making this session a huge success. I would request everyone to kindly fill up the feedback form. Also, the same link will be active for a next session. With this, the session comes to an end. I wish everyone a great day ahead and thank you so much.
Thank you.
Thank you.